Is it ever okay to lie when you are questioned at your pretrial deposition in a lawsuit involving medical malpractice, an accident matter, or even a wrongful death matter? You want to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is unequivocally 100% no. It is never okay to lie. Is it okay to shade the truth? No. Same answer. Is it okay to say, I don't remember? Absolutely. Is it okay to say, wait a second, no one's ever going to find out. It's just a small little lie. It's a white little lie. Who's ever going to know? The answer is absolutely not. I can guarantee you almost with 100% certainty that if you tell a little white lie, a small little lie, something, a factual dispute, a fact that you consider to be insignificant, that you think there is no possible way that the defense can ever learn the real answer to, I guarantee you, and this is true, I guarantee you that at some point during the course of your lawsuit, whether it's during discovery, whether it's during a deposition, whether it is now during a doctor's deposition, whether now you're getting close to trial, or even during settlement discussions, I guarantee you the defense will learn about that little white lie. So you say, what's the big deal? If it's a small little white lie, what's the big deal? It can't impact my case at all because it's so insignificant. You know, if they ask me what was the weather like that day, and I say, oh, it was a blue sky, it was sunny, it was 85 degrees, when in fact it was 65 degrees. It was cold, it was rainy. If I wanted them to have the perception it was a gorgeous day and this driver should have seen what was there to be seen, now if I want them to understand that it's so important that if it's a sunny day, their driver should have seen what was there to be seen. And now, because it's really cloudy, no. If it's cloudy and he couldn't see and there was fog, well, that just gives him an excuse to get out of responsibility for this accident. Well, guess what? There are ways to identify and to go back in time to see what the exact weather was like in the exact area where you had your incident. So don't for a second think that fabricating some small little white lie with a simple little answer that's totally not true is not going to affect you in the long run. And here's something that you should know that not many people talk about. If you happen to give an answer to a question that you know to be untrue, and now maybe it's not 100% true, maybe it's 80% true, or maybe you're trying to shade the truth a bit. Now, the defense, when they find out this information, will do everything possible to paint you, the injured victim, the injured patient, as a liar. They will do everything possible to show to the jury when your case goes to trial that you cannot be trusted. Why is that? They will argue to the jury that if you have told a lie, something so insignificant, about something so small and insignificant, how can the jury trust you about the bigger things, the more important facts, the facts that you have testified to about what happened to you and what injuries you suffered? And the common thinking is, listen, if they told a little white lie about something that's so small and insignificant, then you can't be believed about the bigger things, about the more important facts. No matter how much you stamp your feet up and down that you are telling your truth, no matter how much you claim you are credible and believable, no matter how much your attorney does that, if the defense is able to establish that you have lied about one thing, whether it's small or big, they will do everything possible to show to the jury that you cannot be trusted about anything. Now, there's something else you should know. At the very end of a trial, after the attorneys have made their closing remarks, trying to get the jury to see their client's viewpoint about why they are right and the other side is wrong, the judge will then have an opportunity to give the jury legal instructions that they must follow as they are trying to decide whether or not there was carelessness, whether the carelessness was a cause of your injury, and whether your injuries are truly significant. And as they apply this law, one of the legal instructions that the judge is going to give them has a fancy Latin name for it. It's called falsus in uno. And that fancy Latin name comes down to one little thing. And basically it says, jury, if you find that the witness, that any witness has testified falsely about one thing, you have the right and the ability to disregard not just some of their testimony, you have the right to disregard all of their testimony. That one little legal instruction empowers the jury to be judges of the facts. They are the ones to decide whether you are slightly more likely right than wrong. The jury will be the one to decide whether you are believable, whether you are credible, whether your opponent, the person you have sued, is believable. The jury will have the opportunity to decide who is more believable. And if it turns out that your one little lie has turned the tables against you and now makes your opponent, the person you have sued, more believable, now they have the right to throw out not just some of your testimony, but all of your testimony. And if they do that, you run the very significant risk of losing your case. Why? Because now they will believe your opponent and the people you have sued much more than they believe you. So don't think for a second that telling a small little lie is so insignificant that it wouldn't affect you at all. Nothing could be further from the truth. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.